In an important development, the Supreme Court is slated to hear on September 12th the petitions challenging the constitutional validity of the Citizenship Amendment Act of 2019. The matter will be heard by a bench of Chief Justice of India UU Lalit and Justice S. Ravindra Bhat. The Citizenship Amendment Act of 2019 had come into effect on 10th of January 2020. Amid nationwide protests against the legislation, the Supreme Court had issued notice back in December 2019 in a batch of over 200 petitions challenging the legislation without, however, staying the act. The petitions contended that the controversial act, which liberalizes and fast-tracks the grant of citizenship to non-Muslim migrants from Pakistan, Bangladesh and Afghanistan, promotes religion-based discrimination. As per the petitions, a purely religious classification devoid of any determining principle violates the fundamental constitutional value of secularism and Article 14 of the Constitution. It was also argued in the petitions that the exclusion of Muslims from the Act not only amounts to an unreasonable classification but also violates secularism, which is a basic structure of the Constitution. The Supreme Court had also been apprised by the petitioners that similarly situated persecuted groups such as the Ahmadiyas of Pakistan, Rohingyas of Myanmar, Tamils of Sri Lanka, etc. are not brought under the purview of the Act. This leads to unequal treatment of equals. The exclusion is purely linked to religion and hence it is an impermissible classification under Article 14 of the Constitution. It was contended further by the petitioners. Now, to elaborate a bit on the timeline, back in December 2019, the bench comprising the then Chief Justice of India Bobde and Justices B.R. Gawai and Surya Kant had asked the centre to file a response to the petitions by the second week of January of 2020. Thereafter, in March 2020, the central government had submitted before the Supreme Court that the Citizenship Amendment Act of 2019 is a benign piece of legislation which does not affect the legal, democratic or secular rights of the Indian citizens, and that the legislation has a narrow purpose and ought not to be conflated beyond the legislative intent. However, no date of hearing had been fixed to adjudicate upon the constitutional validity of the legislation until today. Thank you. I'm Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.